founder and managing partner, Bounds Law L.L.C. USA. Yeah. And joining her is an exceptional panel of global experts. Olaf Ungerer, head of Munich office, Gulde and Partners Germany. Thouraya Mathlouthi, Group Legal Director, Data Privacy and Protection, Etisalat UAE. Jose Alconchel, Ungria, founding partner, CPS Patent International Netherlands, and Mr. Justin Pierce, partner, Venable LLP USA. We are honored to have such distinguished panel to guide us through this important discussion. Without further delay, I invite Destiny Bonds and the panelists to take the start the session. Thank you.
Thank you. Make sure you guys can hear me. Can everybody hear me in the back? All right, we're good. My name is Destiny Bounds. Thank you guys so much for being here in this session. We are going to try to keep this a little informal, but we're going to have a few slides for you as well. So maybe don't pay attention to too much of the slides, pay more attention to the presenters. But we are talking about AI and IP, about ownership, protection, regulation, all the things, right? Infringement, and we are going to move kind of through the different types of IP to start with, patents, trademarks, copyrights, and then we're going to talk about it from a contractual perspective, as well as then kind of more of the ownership governance from a different jurisdiction. So, do we want to just quickly introduce each other about who you are really fast and pass it down the line, and then we'll start off with Jose in a second.
Hello, my name is Olaf. I'm a European trademark design and patent attorney and working in Germany, Munich, for a Berlin law firm, international law firm, Gulde and Partners.
Good morning. My name is Alconchel. I am a co-founder of CPS Patent international firm based in Virginia and also in the Netherlands. And we provide patent consulting services to help our clients to navigate better patent protection at the USPTO and the EPO.
Hello everyone, my name is Thouraya Mathlouthi. I'm a French and European qualified attorney. I hold a PhD in IP, and I've been advising for more than 10 years multinational organization on AI, IP, and innovation matters.
Thank you. Good morning. I'm Justin Pierce. I'm from the Venable Law Firm. I lead the intellectual property and AI practice at the firm. I'm based in Washington, D.C., and do a lot of work with my various teams and clients around the world. And glad that I'm here, and look forward to learning from you all as well.
Perfect. And again, my name is Destiny Bounds. I have my own law firm based in the U.S. as well, actually Kansas City, Missouri. We do a lot of business. We do mainly IP, but also business. So I'm going to pass it off to Jose to get started about patents.
Thank you, Destiny. Thank you. So basically today I'm going to speak about the artificial intelligence implemented inventions and how is the approach for patent protection in the United States at the USPTO and at the EPO. First of all, why this matters. When this patent system maybe created more than 150 years ago, maybe was not thought in the sense of the new technologies, and especially what we are seeing now with the development of artificial intelligence and how this is affecting in particularly the new technology. So to what extent actually still the patent law and the patent prosecution is adapted to these new technologies is a question that is always open. But indeed, if you see the number of patent applications and inventions that they are growing and growing, developed with artificial intelligence, this is getting very, very important. And we see that major number of inventions will be developed or implemented with the help of artificial intelligence. So in this respect, sometimes in the patent prosecution or in the life as a whole, maybe you can see that the life is like a pendulum. No? In Europe, we were heavily criticized for many years about how strict the approach was for patent protection. In particular, I remember that it's not allowed to do business methods protected in Europe. And somehow this has been criticized in other areas. At the United States, probably we had in this respect, a party which everything was patented, if I can say so, but somehow things have changed. And actually, there was a decision in 2016 about the decision of Alice and Corporation Asiles Bank International, a decision of the Supreme Court that basically changed a bit the paradigm of eligibility in the USPTO. And suddenly many ideas that were already patented were put under question about how these abstract ideas could get patent protection. And somehow there was, I would say, some uncertainty and unclarity what was patentable, what is eligible in the United States. So it will appear that suddenly the system, the pendulum, moved from one place to another. Whereas, at least as far as Europe is concerned, the system has been quite stable, strict indeed, but somehow predictable that what you can get protection in Europe or not. Of course, there are new winds in the United States. The new director of the USPTO, John Squire, has come with a new wind and a new impulse to change the way, the approach that the USPTO is taking in relation to the protection of AI implemented patent inventions. And I think recently, this has been past October or November, the decision of ex parte Desjardins has introduced the fact that patents which were not granted by the PTAB or whatever suddenly have been reviewed, and they have introduced that yes, if there is a technological advance or whatever, they cannot be considered as an abstract idea, and therefore they can have the merit to move into a patent. So somehow the USPTO is moving forward to the idea that let's focus on the 101 eligibility criteria and allowing more to move into the analysis of novelty, inventive step, inventive activity, and sufficiency of disclosure. So more in the focus that the patent application examined by patent examiners move more in the direction than to be excluded as the fact in their eligibility. Well, this is what is coming now at the USPTO, but the question nevertheless is not depending only on the USPTO. It depends on the decisions which are made at federal courts, even at the Supreme Court, which actually creates the case law. And this is why one of the initiatives that is pending now in the United States is called PERA, I don't know how it's pronounced in English, is the Patent Eligibility Reform Act, which is pending now, and is a bipartisan proposal in order to clarify, to make it clear for the patent applicants what is patentable, and to try to, especially to reinforce the idea of artificial invention applications are important and they have to be patented, especially in some areas like medical diagnosis and other technical areas. And this is pending. Of course, not everybody is happy with this. I mean, it's always, in this respect, you have pros and cons. But you have to say that other people can think that the patenting of very broad patent claims in this artificial intelligence can create problems downstream, especially because this is going to create also uncertainty and problems when enforcement and litigation. So the question now is there some sort of a convergence between the EPO and the USPTO? Is a question that is moving towards more harmonized project. Just think that at the EPO in Europe, the key question is about the technical effect. The technical effect to solve a technical problem with technical features. This is the key question. And well, of course, this is something that at the end, whether it's patentable or not, it depends on the inventive activity, and only the features that are technical, that help to solve this technical problem, can lead to have a patented claim. So basically what I wanted to say is that if in this global world, in this global business, and if it's possible to focus really on the new technologies and maths and algorithms, what can be patented or what not. Of course, either at the USA, if we have technological improvements, or if we have in Europe things related to AI algorithms that are going to solve technical problems, you can find the appropriate place or the appropriate path to get the patent protection. And I think that what is important here is that in this global business, if you are going to have protection, multiple filings is become more and more relevant, more and more important. And if you have the appropriate drafting experience and the appropriate tips to focus on the essentials, on the things that you see that you can get patent protection, this can lead to a comfortable way to get patent protection in Europe and the USA. So this is my message to you, that a proper understanding, a good drafting tips on these inventions applied with computer and with artificial intelligence and with algorithms can be of maximum interest for you. And this is the takeaways today. I think somehow, hopefully, we are seeing some approach and some convergence between the USPTO and the EPO. I think if you focus really on the important parts, well designed, good drafted, good disclosure of the invention, very important. I forgot to mention about the importance of the sufficiency of the invention. And then you can move to a unified global patent strategy that can be used if you are having a global business. So thank you very much. Thank you for your questions.
Awesome. Thank you, Jose. Okay, Olaf, let's build on that. Yes, we can clap if you like.
Thank you.
For the...
And my presentation will be related to the European system, but there are some similarities with the US. It's just minor differences. So here you have a broad overview over AI systems, AI inventions, and what you can see, this is a very complicated technology. The outer part is the artificial intelligence, and as it goes more into the core, it all depends on the outer level. So at present, as you know, an important role is the generative AI, and there are very complex models and neural networks involved. So what we can see here, it is apparent that patents alone cannot be the right way to protect this, or the complete way to protect this. One thing I should mention in advance, because we're talking about IP protection, and I will also include trade secrets in my presentation, but from a legal perspective, trade secrets are no IP rights because they don't provide exclusivity. So it's not an exclusive right. What is an IP right is patent, trademarks, and copyright. So this is important just to know, because I'm now talking about IP, but to be honest, exactly trade secrets don't fall under the expression IP, just to mention. So you see there is a very complex situation here from a technical point of view, and now we need to know what is the business value. If you have a company using AI inventions for business, we need to check where is the business value, and we can see we have models, algorithms, we have software embedding this, we have training data and output data, and of course we have lots of new hardware, because as you have got notice from the news where these generative AI centers are established, you have vast companies with vast energy requirements, so there is huge processing power required, and this means that there will also be hardware inventions, hardware-related inventions, new computer systems like quantum computer systems, and all this of course implies inventions. But one problem that we can face when we look at the patent protection is always it gets published after 18 months, and so you publish your maybe desire to be hidden parts of your AI. And this is always a pathway, a borderline that you need to pass to see what can I publish and what do I want to remain hidden. And this is exactly what also the business value comes from. So it's clear that we need a strategic IP mix or a layered strategy to protect AI-related inventions. So we have no single IP right that covers this. So what IP, and I mentioned IP in Marx. So we have the trade secret, which is actually not an IP, and this is information that is not known and provides commercial value by being not known. And this is by law. This is, I will come to that later in the EU law. This is a requirement, and you have to provide measures, adequate measures to protect. So if you want to sue someone for infringement of trade secrets, you need to show that you applied these concepts. Then we have, of course, the copyright, especially software code falls under copyright. So you see this is a quite limited thing with a copyright protection, but it can be very useful because it protects the code itself. Then, as we just heard, it's patents, and we also have the utility models in some of the European countries. So I will come to that also later a bit, what is the difference and what is the advantage. So as you can see here, we need to have a strategic mix of IP to get this somehow protected. And the suggestion is in this request to have all information that needs to be hidden can be protected by trade secrets. And for trade secret protection, there is the so-called Trade Secret Directive in Europe. It was established 2016, and it provides the advantage that we have now an enforcement system that is similar to patent protection. So you can really get injunctions and all these issues and damage for trade secret infringement. But there are two requirements here to get this trade secret protection according to this directive. It must be secret, and it must have a commercial value because it is secret. That needs to be shown, and you have to it has to be subjected to reasonable protective measures. What does it mean, protective measures? That means contractual, that means physical. You need to install some data protection things, and you need to provide alarm systems, and all these physical and also contractual measures with the staff to ensure that this is reasonably protected. And of course it depends on the size of the company. If you're a small startup, the requirements are less than if you are a big global company. The courts expect more measures if you are a larger company, of course. And so you have to take active steps here. And so what are protection measures? Practically restricted access, password protection, decentralization, contractual measures, employees, protection and by special clauses in contracts, and legal measures. That is, you also have to show that you prosecute misappropriation. This is important. So if you do nothing and just tell me this was a trademark infringement, that might not be enough. So you need to show that you actually actively prosecuted this. And this is one thing, and of course this is especially for hidden algorithms, data sets, training data. This is very interesting to do this by trade secret protection and clearly document this. Then for the technical applications we have patent and utility models. For patents it's very important to see there are two aspects how this can be protected. One aspect is if you apply AI in connection with a technical application, for example, for identifying specific image objects. This can be something, or it can be used in connection with other technical applications where AI provides an improvement. And of course, you have to show that it is a technical effect and it is non-obvious. And A disadvantage of patent protection is also you have an examination. It takes a long time, and there the utility model comes into play. The utility model is an unexamined right, so it has the same strengths as a patent, but the utility model is registered within weeks, and you can have a very fast protection. But of course, validity will be checked when you have an infringement suit for utility models. But anyway, utility models can even be, according to German case law, can be used for software on a data carrier. So there is recent case law. So actually, you can also protect AI-based software with a utility model, and this makes it very interesting. And the third thing is the software and the copyright protection. There we have a software copyright directive in Europe. And directive always means that it will be implemented into national law by each of the countries. So this is like a general guideline that has to be followed by all the countries, but the countries can do their own national law relating to such a directive, but they need to do this. And what is the requirement here for copyright? It needs to be original. So that's very important, that you do a documentation that you are the original creator. Another problem is if you have AI output, that is a machine output, so that is not sufficient for copyright protection because you need to have a human creator. And so in copyright things, you need to show that the output has somehow been modified by a human being, but that can be done, and then you would have the creativity required for copyright protection. So actually, it is possible, even AI output, there can be a protection by copyright. And interesting thing for copyright is that legitimate test and use of copyrighted software is not protected, but only if you use it for commercial reasons as a user. And important, this makes the line of difference between patent and copyright is that in copyright there is no functional protection. So you can't say, I have this loop in my program is protected by copyright for the function it does. It's just the code that is protected, and the infringer has to use substantially the same code and a substantial part thereof. So it's not just a small 2 or 3 lines of a software code that is protected here. So these are the different IP protection options we have. So to end my presentation, I would say if we look at all these things, we can say what is interested in trade secret is that we have a very broad range of information that can be protected. It's not a technical effect requirement, it just needs to be secret, and you need to show that you have done adequate measures. It is low cost, it is a transferable right, of course you can transfer it, there is no formal registration. But with trade secret, the problem is reverse engineering is allowed. So if one of your employees can have access to one of your AI inventions in an apparatus or so, and it is possible to reverse engineer, he is allowed to do this. So there is a high risk of leakage in relation to trade secrets. And it's of course a complex proof of infringement, because you have to prove that it is the same information, you have to document it in your company. This is the problem. With copyright we have the advantage, no formal registration, a long-term protection, it's plus 70 years from the death of the author, and low cost of course. But we always have the problem with the ownership. You have to show that it is a human creator, especially in AI, and the originality has to be proved. So there should be, in US you can register it, not according to the Berne Convention, copyright does not need to be registered in Europe. So actually what you can do is you can deposit it. That's what we often advise to our clients. If they have something that needs to be copyright protected, deposit it with a law firm or provide a good documentation in your company. And patent and utility models are strong exclusive rights, so it doesn't depend whether somewhere else has done it before or so. If you have the patent protection, normally you have the right, and it can be detected based if someone proves that he was earlier in his invention. But in general, copying is copying is not allowed. So even if it's earlier, you have the patent right. It's an exclusive right. But the problem is publication, of course. you have the risk of rejection. You may get a very small claim granted, although you get a very broad publication. So this can be all risks. So what are some to-dos if you want to protect your AI inventions? You should normally consider, if you have an AI invention, what is the technical effect, what is the technical contribution? Because as you know, if you want to have patent protection, you need to have a technical effect. And even non-technical features can contribute, but you have to show what is the technical contribution. Then you have to have regular trade secret measures and revisions and education in your company to provide support for these reasonable measures to have. And one thing that I forgot to mention is in the EU, you might have known that we have this AI Act and we have the GDPR. These are laws that to somehow challenge trade secrets, because if you use user data of the public, the user subject is allowed to get information, disclosure requirements and transparency, how the data is processed in the AI. So this means there is a kind of leakage by law, which gives a problem, and this is also a difference to the US, where you don't have these strict data protection requirements. That would be all from my side. Thank you. I think it was a bit too long, but it's okay.
Thank you, Olaf.
Thank you.
All right, Dr. Thouraya, let's talk about the UAE perspective and AI ownership and rights and all that.
Thanks, Destiny. I want to thank my fellow panelists for such a detailed perspective on Europe and on IP protection in Europe. So I'm gonna share my own perspective of an in-house counsel, having worked in the United Arab Emirates for 5 years. So for me, the main two issues, I'm gonna focus also on generative AI concerns. So for me, the two main issues are related to the training of data set. And while training dataset is when it uses massive amounts of copyrighted data, such as text, images, etc., is considered as infringement. Should the authors of such works, which work is used actually to train large language models, and which serves to the GenAI output, should they be recognized, and should they be compensated for such use? And the second issue and concern that I'm gonna look into is the ownership of GenAI output, and whether it is considered as copyright and protected by IP within the UAE or not. So in terms of data, the use of copyrighted data for the training of large language models and for GenAI, so far it is creating a tremendous issue for artists and authors because they're struggling to assert their rights, while at the same time GenAI models are actually extracting tremendous value from the training of copyrighted data, and are not even recognizing or compensating the authors. So is it considered as infringement or not? So there's not a doctrine in the region considering that as infringement. However, this results in a loss of revenue for artists and the owners of such copyrighted content. So the only option would be to resort to litigation. And so far in the UAE, and I haven't heard of any recognition within the region. I'm not aware of any litigation where the courts have recognized the rights to authors when they had claims about the use of their data for the training of models. What I know and what I have encountered as an in-house counsel is that can constitute a major risk for the organization. Therefore, it is very important to really audit the data sets and make sure that you're not using any copyrighted content. Contractually, you need to also have strong clauses where you make sure that you protect your own organization data when you have partnerships in AI projects. So recently, for example, I have worked on a major telco lines project, a large language model, which was a partnership by Etisalat with 5 major telecom players all over the world, including Dutch Telecom, Korean Telecom, and so on. So I know that one of the major issues we have focused on and we have ensured to protect within the contracts is make sure that our data is not then used to train the models, the AI models for our partners. Then the second concern and the second major issue is related to ownership of Gen AI output. So the UAE and the GCC legal framework does not recognize Gen AI output, does not recognize any copyright for Gen AI output. So it only recognizes purely human authorship. So there's none.
There's none. Sorry, I'm just really curious. So they
Yeah.
don't recognize at all.
Yeah.
You
So
can't put anything into it.
So far we have the UAE federal copyright law dated 2021, and there's only a recognition for purely human authorship. So there's no such recognition.
That's fascinating. Sorry, I don't mean to interrupt, but
I think it's pretty similar
in the U.S.
Yeah.
I'll let Justin speak to that in a second.
Yeah, sure. Yeah, no, there's no such recognition. So the more autonomous the output is, the less recognition it has. So if it's purely Gen AI and autonomous content, it will pretty much fall in the public domain.
Yeah. That's good.
Yeah. I think there are a lot of cases, and there's a lot of there's a lot to cover. So I think this constitutes a tremendous opportunity at the same time for the UAE to create policies where they're going to focus not just on the aspect of the authorship, but rather on the compensation, and to create policies that focus on licensing arrangement, revenue sharing models, to ensure that authors and artists can be recognized for their work and can be compensated for their work. So that creates a tremendous opportunity for the UAE, and this is particularly important for the United Arab Emirates as they have an AI strategy called the AI Strategy 2031, where they really want to enable innovation, and they want to protect copyright, and they want to protect authors and artists, but at the same time they want to be an AI first country and an AI first nation, and they want to enable innovation. So I expect to see such policies in the future, and I expect to see the UAE leading the way in terms of policies enabling the compensation and the recognition, and highlighting more transparency on the use of copyrighted work. And with that, I leave it to Justin to provide more details on how it happens in the US.
Yes, go ahead.
Thank you. All right, how's everybody doing?
You awake?
All right, this is always a good time. I enjoy doing this. I'm actually going to stand up. Why don't everybody stand up with me? It's nothing like making human biology go to work for you. All right, now let's sit back down. I'm actually going to remain standing. And being a lawyer, I should have said, if you're able to stand. All right, didn't put a preface in front of it.
No pressure.
So I'm just standing because I typically do. We've had some great presentations so far. I'm going to cover a little bit and focus in sort of how this all works with AI and contracts and licensing. A lot of what I'll focus on is going to be transactional in nature, but I will talk about some of the risks that many companies and many clients of mine are in the midst of right now. Earlier we heard discussion, and it is true, while there's a lot of litigation that you hear about in the news media that relates to copyright enforcement and whether you might have copyrights, as we spoke about, that could be enforced at the output level, the input level. One thing that's happening for sure is corporations aren't waiting. They're going right into transacting with one another and doing business in different ways and trying to leverage the technology, whether it's generative AI or other types of AI technology, to enhance their operations and integrate it in all their uses. So a few quick things that come out of a pretty comprehensive checklist that my team uses when we kind of advise corporate clients around the world, not just in the US. A few considerations that I'll hit here are when you do have AI agreements, and I'm speaking from the standpoint, just like many of you all probably experience, where you have clients that have asked you to maybe take a look at a licensing agreement or a contract on behalf of their company that they might be doing with some AI vendor. These are key things to look at in terms of the checklist, and I'll run through a few of sort of why they're important. So one key thing that we're seeing in a lot of agreements actually has to do with performance warranties and service level agreements, sort of your response times or up times that you might expect a particular software to work for a company that you are representing. What we're seeing a lot in the world of AI, because there is a lot of risk and a lot of questions as to whether the AI actually does the particular task that it's suited for, is being very careful when you draft those clauses to make sure that AI, if you think about it, evolves as you go. Where you may be one day with your learnings and data, maybe one spot, but it kind of moves. There's these concepts called AI or model drift. There are issues in terms of who upstream from you, where the data comes from. Earlier we had a discussion, I think Dr. Thouraya talked about a project with many other companies. Many times to make a product really fit for purpose, your client or company you work with is pulling data from many different sources. So you do have to be careful in terms of what warranties that particular AI vendor or supplier or software supplier is actually giving to you. We've talked a lot and we'll continue to talk a lot about outputs, derivatives, and inputs and improvements. A couple really important things to put in here that haven't been covered already, particularly when you look at things from a contractual standpoint, is many times you'll have an AI vendor that you might hire, your company might hire to do a particular task. They are using your, for instance, data to do some specific task that's fine-tuned for what you do. Oftentimes that work that your IT team is doing on top of what that AI vendor is doing is something that might be considered a derivative work. So it's very important to look at what your contract says about who owns that derivative work, and if that improvement that your IT team has to do to make that system work on your system is something that would fall under that. Many contracts, if you take the default language in there, it would mean the AI vendor owns the results of what your IT team did to fine-tune things. Moving through and to keep this going, I do want to make a distinction here. While I'm talking a lot, obviously, about AI contracting and licensing, I'd be remiss not to mention how much AI governance plays a role in your contracts. This is another big point that if you take away anything from what I have to say today, obviously, I get into a few of the tricks of the trade, but AI governance, you hear that lathered about a lot. If you ask people in most companies, particularly senior executives that I talk to every day at boards and things like that, oftentimes they have varying sort of understandings of what that means. One thing it does mean is in your contracts, you need to have mechanisms so that at some point, all of you all, whether you're in-house or doing what you do for companies outside, have the ability to help that company do some quality control in the output or outcomes of what its software does. And so one example of why governance is important and why contract provisions that relate to AI governance aren't just talk is in contracts, most of the times you will have something like audit rights. Many times people who do software contracts or software as a service contracts are used to working from templates. You tend to gloss over what are the different requirements for audit rights. With the AI world, I have been counseling clients and I've seen this in real actions. I'm in a case that we're dealing with it now where we have one client that wishes it had been more strict about the audit rights that it included in the contract. The reason why is in a particular jurisdiction, their AI was doing certain things where over time, with updates from another provider, its output or performance was becoming more and more biased. It was picking a certain type of scenario over anything else, and over time, this particular tool, in a sense, became less and less effective. The number of complaints went up, and then people started complaining to the local government. So imagine if this particular client already had an audit provision that said anytime you make an update, software vendor, you have to let us know or let us check out what that automated update is so that it's not impacting how our performance is being perceived from a perception level and from a real quality level. I can bring that as a real life case that's happening now. Another issue, it's down at the very bottom, are, I'm skipping through some of this for the sake of time, are making sure there are good provisions in there for termination as well. You think about the situation that I just talked about. Sometimes you can start off in a great relationship with a particular client, and you may cut it. You may have a good agreement in the world that it used to be before AI, where you terminate the agreement. Unfortunately, there are these concepts now, or technological artifacts that often remain. If you have, just like I talked about the scenario before, where your IT team is fine-tuning an AI to work for a particular purpose within your company. Remember, this data is moving both ways. So there may be something on top of you, what I call upstream, meaning the vendor itself is learning from how you are using the data over time. Those learnings might be different from them owning or taking your content. And one way this is actualized is something called embeddings. I won't get into this heavily a lot from a technical side, even though I've done a lot in the programming world. I'll just leave you with this. Many times, the same way, if you think about what I talked about before, that your IT team is making modifications in software to make something work better in your system. Oftentimes, to have those high levels of SLA, response times and quality measures, the AI vendor who's offering you a particular service is also modifying and learning, and they're being adaptive based on what you're doing. They're using vector-based software through AI, where maybe there's certain data that you have. They have not copied the data, but it might be represented by a string of numbers. I'm trying to simplify something very quickly. You'll hear a lot of software people in the AI space call this embeddings. There's a debate as to whether those embeddings are something that's a derivative work. Are they protectable in themselves, or are they something earlier, like Olaf talked about, that would be entirely functional because it's just for a software placeholder to make something happen at a certain point in the process? I bring that up again because that kind of complexity didn't even exist before maybe 2 years ago. I bet you, all the companies you represent, are sitting on a bunch of contracts that have not been updated for that scenario. So, a few other things here I think that are important to mention. Obviously, we're in the game of trying to optimize licensing and reducing risk. A few of the bullets here that I think are very important. I've talked a little bit already about training and tuning. I think it's very important to look at license scope, the license provisions in these types of agreements. I think it's very important in many cases to try to retain ownership of licensed content and data sets. And sometimes you can be a bit overbroad. I've had deals where you have both clients who've been told by their lawyers and they're acting in good faith, oh, you should own everything. Well, then you still may not actually get a deal done. Oftentimes, the way you can meet in the middle is having field of use requirements. Think about the big picture. Why do you want a particular data set? Is it because you're using it for a particular market? Maybe you can restrict it to a field of use for that particular market so that the vendor or the other party who's giving you a license or has something you want feels like there is a lane that they can stay in as well. But that's a thing to think about, because oftentimes if you just take the law school or pure lawyer approach, you would have no deal. It's been talked about a little bit earlier how important this is, but one of the keys for risk management in any of the contracting or licensing areas when it comes to AI is making sure that you have a way to make sure there is lawful sourcing and make sure that rights clearance representations in the reps and warranties clause are accurate, or at least you have the ability to go back and hold that vendor responsible for maybe not being truthful about where they source the data, particularly if it's copyrighted that they're using. There's no question, so many studies have already shown that it's the copyrighted data out there that's the highest quality. We're in a world now where many companies are running out of truly organic data. Obviously, there's a lot of ways to generate synthetic data or represent different patterns between, let's say, words per se. But at a certain point, copyrighted data, original data is always the best, and that's what you pay for more, higher. I've certainly seen that experience, not just in studies, in terms of the quality of a licensed data set. It matches that premium pricing. So lawful sourcing, rights clearance representations are important. I'm going to skip down to the bottom just a little bit on economics and competition limits and enforceable remedies. Again, a lot of times the remedies portions and agreements are something that people tend to look over. I would say for two reasons. Many agreements are written oftentimes from a US or European law perspective. In the US and the software world, there'll often be these sort of boilerplate provisions that talk about all types of damages, consequential damages, liquidated damages, and many lawyers sort of, not just users, but many lawyers will gloss over these. It's important not to do that, particularly in the international sense, depending on where you're dealing with licensing. There are many regions of the world, I can think of some countries in this region where you could actually get consequential damages. So I've definitely seen these things where you have agreements that were written for one jurisdiction, thinking about damages in one context, where you couldn't even get damages in a particular country. That's important in the AI world, I learned in particular, because many of the companies that I've worked with and represent might be looking for particular text. They might be looking for Arabic audio and visual. So where are they going to get that? But in Arabic-speaking countries. The law there may be different with respect to damages. They haven't even thought through sort of that aspect if something was to go wrong. So again, things to think about when you are dealing with any kind of contract or license that deals with AI. Last but not least, a little bit on me. I think you've heard enough. We'll move on.
Thank you so much, Justin. I think I got the look that there's not time for questions, or do we have time for questions? I think we do. There's also, before, so I don't forget, here's contact information for all of us if you want to reach out to. I think we got great.
Hi everyone, thank you for this session. My question for Jose, it's interesting that you were saying that you are looking to see the US and Europe converge on examination of software and AI applications. It's also my understanding that the US is way more on the abstract, one-on-one kind of idea, while Europe is more on technical solution for a technical problem and for inventiveness. Don't you think that with Kim Memo coming out last year, that this gap is really going down? They are trying to ease more on this abstract idea and go towards the European way of doing examination for inventiveness?
Well, I wonder if it was a bit of wishful thinking from my side in respect of this convergence it's in. But I saw in the United States the situation in which there was this kind of uncertainty and clarity about what is eligible or what was not. And I think now the push to move forward, I think that the two steps system that they have at the USPTO to assess the eligibility is correct, is operable. I think it's a clear push trend to get things more eligible, or let's put it that way, just to pass the threshold of eligibility and to concentrate really in what's important is novelty, inventive activity, sufficiency of the invention. And definitely, if patent applicants in the United States want to be sure that they're going to have a patent, if they focus on the real things, I would not say imitating, but somehow getting inspired, but also maybe more strict systems at the EPO, can go further to these things. And this can be extrapolated to other jurisdictions, definitely in India and in China. Having this global patent strategy can helpful to get a global protection. But okay, let's see what happens with the PERA. I have to pronounce PERE. What happened there in the United States, and what that brings in the United States.
Thanks. Any more questions?
Thank you very much, everyone. This question is for Jose. You mentioned, is actually follow up to the question of the other guy regarding the, not necessarily the convergence. You mentioned about the eligibility bills or legislation that will go through the Congress and they're pushing it in. And if we are talking about the same legislation that I am thinking regarding the eligibility, is it not going to take, if that get approved or become law, it's not going to take the U.S. regarding eligibility before Alice case, or is it going to change the two-step and make it easier for the software or business processes to become patent?
Yeah, that's indeed the idea. What I see is that as Alice created a new paradigm, I think the idea of the legislators is to as you said, to get more clear the eligibility. I think to clarify what is eligible, what is patentable. Sometimes you have to think per se, again, what is the purpose of patents? Sometimes you have to think exactly why we are getting patents and what is the purpose of patents. How these patents are going to be enforced, how you are going to be litigated. I mean, it's easy to deliver patents, and then what you have is a tool that can be quite problematic even for the society in terms of litigation and enforcement. This is the idea. In principle, they want to move away, to be less strict in Alice. Again, it's a bipartisan thing. I see pros and cons. Well, it's up to the legislators to hear.
The point is, the U.S. is not going to come, if that's going to become the law, so it's not converging, it's diverging from what the EU is. But one other question that I have, like there was a case, it was last year in the UK, that they said like AI is patentable.
Is what?
Is patentable. It can be patentable. There was a UK case.
Yeah,
but kind of, if AI can be patentable, which there was many discussion that is the Europe or the UK are becoming like having software in the next step, the software is going to be patentable too, because AI is, in a way, is a software.
But AI in Europe is patentable as long as it has a technical application and it has resolved a technical problem in a technical way. Definitely in Europe, and applies also to United Kingdom.
Yes.
If you have an AI invention which has a clear technical problem solved, or focus on the real hardware benefits of the system, is patentable.
Yeah, I mean, that has been like that. If the software depends on the hardware, you can patent it.
You can. Yes, you can patent it. So it's
in the EU.
Indeed.
That has been always like that.
Yes, indeed.
But my focus is more like this eligibility issue that it becomes law.
In the
and
States.
There's going to be divergence.
In the United States, yeah, indeed you are. I was a bit provocative as well here with the audience. I don't know if the conversion was a bit more wishful thinking or a reality, but
Yeah, it's diverging. It was after AIA Act, it was converging, but now again,
Let's see.
Yes,
good,
very
thank
good.
you.
Very good. One more question? Great.
Hi, my question is for Justin. So Saudi Arabia just announced, I think it's already implemented, a global hub AI law where essentially they're going to have what they call like digital embassies, where a foreign government or a private sector can set up a data center to process data for their citizens, but it will be located in Saudi Arabia. So I don't know if you have any examples or cases where you've come across AI systems or use of AI that's been trained in one jurisdiction but implemented somewhere else where the framework, they're essentially applying two different frameworks, which leads to this issue of, okay, does the AI follow the framework from where it's modeled or where the actual users of that AI is going to be in place?
Yeah, no, that's a great question. So a few different answers because I could go on that for a long time. Good, timely question because there are a number of companies, multinational companies, wrestling with that right now as we speak, and they're all answering it in different ways. And I would say in relation to maybe their risk profile. So one example I've seen, I like the fact that you brought up this Saudi initiative with sort of these sovereign data centers. So there are companies that I've worked with, and I think of one specifically, where that was sort of a blessing in disguise for them because they were trying to understand how to have more of their software or more of a presence within, let's say, the Gulf region. So they were very concerned maybe a year prior about how strict the PDPL or the Saudi data law was. That gave a good example where let's follow that exactly and have data and services that are housed there that not only we could use for some of our products to go after customers in the Gulf region, but in Saudi and not have to worry about it. In other jurisdictions, though, because of the lack of maybe that kind of foresight in a regulatory sense, I've seen some companies, some that are more conservative, going as far as separating the data architecture. So you might have some servers and data, if you kind of think of the European way, data controllers, that might actually be set up in the US, in like Virginia or California somewhere, and then they might have an entirely separate setup and a corporate structure-wise housed in Europe, just for that particular market. And the data is processed in two different ways. Obviously, there's more expense with that. That's not what every company is going to want to do, or maybe even has the resource to do. And I would say there's sort of a third group, which is the biggest group of companies that are torn in between that and trying to figure out which way do they go. And I hate to say it, they're making sort of risk-based and measured decisions about which rules do we actually think we can comply with and which are we not, and we'll hire lawyers and lobbyists to take care of the rest.
Very good. Awesome.
just one more
Oh, I don't think I'm supposed to take any more questions. Okay, guys, if you really enjoyed this session, though, shameless plug here, session 6 tomorrow is more focused on copyrights and AI. I've got some of my panelists back there and I'll be speaking. So if you want to ask more questions related to that, come tomorrow. Yeah, I think we're getting booted out. So thank you guys so much for joining us.
Thank you, Moderator. Thank you.
So on behalf of IIPLA, I would like to request Destiny to please present the mementos to our as a token of appreciation to the panelists. Thank you.
Take that off. Really impressive. Thank you. That picture. Thank you.
Last but not least. I'd love to have your slides. Those are very interesting to me. And many of the things that you have mentioned are just encouraging. Yeah, definitely.
I request you to please come forward for the
in-house and telecom.
Can I request everyone to be seated? The third session will start momentarily. Thank you.